Alaska has a moderately regulated breaking lease framework with a statutory duty to mitigate and broader fair housing protections than many states, combined with practical challenges unique to the last frontier. The governing law is found in the Alaska Uniform Residential Landlord and Tenant Act, Alaska Statutes, Title 34, Chapters 03, which addresses the landlord's obligations when a tenant vacates early. If you're a landlord or tenant in Alaska, the URLTA provides a workable statutory framework, though the state's extreme geography, climate, and housing dynamics create breaking lease situations unlike anywhere else. Let's start with the landlord's duty to mitigate damages. Under Alaska Statutes Section 34.03.2130, when a tenant abandons the property or breaks the lease, the landlord has a statutory duty to make reasonable efforts to re-rent the unit. Alaska's mitigation requirement is codified. The landlord cannot leave the unit vacant and hold the departing tenant liable for the full remaining rent without making genuine re-rental efforts. The landlord must take reasonable steps, advertising, showing, and accepting a qualified replacement tenant. The departing tenant's liability is limited to rent during the vacancy period, plus reasonable re-rental costs. If the landlord fails to mitigate, the departing tenant's liability is reduced by the rent the landlord could have collected through reasonable efforts. What constitutes reasonable mitigation in Alaska may differ from the lower 48 due to the state's unique market dynamics. In Anchorage, where the market is moderate and most advertising and showing infrastructure exists, the mitigation standard is similar to mainland expectations. In remote communities accessible only by air or water, where advertising options are limited and the applicant pool may be tiny, reasonable mitigation looks different. Courts evaluate reasonableness based on the specific circumstances, including the geographic realities of the Alaska rental market. Early termination clauses are generally enforceable in Alaska. The state does not cap early termination fees. A clause requiring 30 to 60 days notice and a fee of 1 to 2 months' rent is typical and enforceable. Alaska courts enforce reasonable contractual provisions. Given Alaska's high rents, particularly in Anchorage, Juneau, and Fairbanks, even a 1-month fee represents a substantial dollar amount. Alaska's URLTA includes provisions regarding prohibited lease terms. Under Section 34.03.060, certain lease provisions that waive tenant rights under the Act are unenforceable. A provision that eliminates the landlord's mitigation duty or imposes the full remaining rent as liquidated damages without accounting for mitigation could be challenged under this section. Military members have the right to break a lease under the SCRA. And this is critically important in Alaska because the military population represents one of the largest segments of the rental market. Joint Base Elmendorf-Richardson, known as J-Bear, in Anchorage is one of the largest military installations in the Pacific. Fort Wainwright and Eielson Air Force Base near Fairbanks generate significant military demand. Coast Guard Base Kodiak is the largest Coast Guard base in the country. SCRA lease terminations are an everyday occurrence across Alaska's military communities. Military families serve 2 to 3 year tours in Alaska, and every rotation cycle generates a wave of lease terminations. Active duty service members with qualifying orders can terminate by providing written notice and a copy of the orders. The lease terminates 30 days after the next rent due date. No early termination fee or penalty applies. Alaska's BAH rates are among the highest in the nation, reflecting the extreme cost of housing. When a military tenant terminates under the SCRA, the landlord loses a tenant paying premium BAH-driven rent. But the constant influx of incoming military families means the unit can typically be re-rented to another military family at the current BAH rate. The cycle is predictable, and landlords who serve the military market should treat SCRA terminations as a routine part of operations. Alaska has enacted protections for victims of domestic violence and sexual assault that allow early lease termination. Under Alaska Statutes, Section 34.03.360, a tenant who is a victim of domestic violence, sexual assault, or stalking can terminate the lease by providing written notice and documentation to the landlord. The qualifying documentation must include a copy of a valid protective order or a copy of a police report or written report from a peace officer documenting the domestic violence, sexual assault, or stalking. The tenant must provide written notice. The statute specifies the requirements for the notice period. When a domestic violence victim terminates under Section 3403.360, the tenant is responsible for rent through the termination date, but is not liable for rent for the remainder of the lease term. The landlord cannot charge an early termination fee. The security deposit must be returned according to standard rules, within 14 days if no deductions, or within 30 days with deductions. Alaska's provision includes privacy protections. The landlord must keep the documentation confidential and cannot disclose the tenant's status. The landlord cannot use the termination as a basis for negative references or future denial. Alaska's provision also addresses lock changes. The victim tenant can request that the landlord change the locks, and the landlord must comply within a reasonable time. If the perpetrator was a co-tenant, the lock change excludes the perpetrator from the unit. Tenants in Alaska may break a lease if the landlord fails to maintain habitable conditions. Under Alaska statutes, Section 3403.100, the landlord has a duty to comply with applicable building and housing codes, make repairs necessary to keep the premises fit and habitable, keep common areas safe, and maintain essential systems, including heating, which is critically important in Alaska's extreme climate. If the landlord fails to maintain the property, the tenant has remedies under Section 34.03.180. The tenant must provide written notice identifying the deficiency. The landlord then has 10 days to make repairs for non-emergency conditions. If the landlord fails to act within 10 days, the tenant may terminate the lease. Alaska's extreme climate makes certain habitability failures far more urgent than in temperate states. A heating system failure in Anchorage or Fairbanks during winter, when temperatures can reach 40 or 50 below zero, constitutes a genuine life-threatening emergency. A landlord who fails to restore heat within hours, not days, during an Alaska winter faces potential liability for damages well beyond the lease context and gives the tenant grounds for immediate termination. Pipe freezing, roof ice dams, snow load structural failure, and inadequate insulation are additional winter-specific habitability concerns that can trigger lease termination rights in Alaska. Conditions that might be merely inconvenient in a mild climate can be dangerous or deadly in Alaska's extreme cold. Alaska also recognizes constructive eviction. If the landlord's failure to maintain the property or affirmative actions, shutting off heat, failing to address structural damage, changing locks, render the unit uninhabitable, the tenant can treat the lease as terminated. Given Alaska's climate, constructive eviction claims carry particular weight. Courts understand that uninhabitable conditions in Alaska can have severe consequences. Alaska has specific abandonment provisions under the URLTA, under Section 34.03.230. If a tenant abandons the property, the landlord can retake possession after following proper procedures. The landlord must determine abandonment based on the circumstances: absence from the property, non-payment of rent, removal of personal belongings. The landlord should document evidence of abandonment before entering. Alaska's abandonment situations can be complicated by the state's geography. A tenant in a remote community who stops communicating may have left the state, or may simply be dealing with communication challenges in an area with limited connectivity. Landlords should make reasonable efforts to contact the tenant before treating the property as abandoned. The departing tenant remains liable for damages after abandonment, subject to the mitigation duty. The landlord must make reasonable efforts to re-rent even after abandonment. Alaska's permanent fund dividend is relevant to the breaking lease context as a practical matter. Many Alaska tenants rely on the annual PFD payment, typically $1,000 to $3,000, as part of their financial planning. Some tenants time lease breaks to coincide with the PFD distribution, so they have funds to cover early termination fees or deposits on a new unit. Landlords who are aware of this dynamic can work with tenants to time transitions in a way that reduces financial stress and improves the likelihood of collecting any amounts owed. From a practical standpoint, Alaska's rental market is unlike any other state. Anchorage is the dominant market, home to roughly 40% of Alaska's population. When a tenant breaks a lease in Anchorage, re-rental is moderate, typically 2 to 4 weeks for well-maintained units. The military population at Jayber represents a substantial portion of demand. The economy is driven by oil and gas, military, healthcare, government, and logistics. SCRA terminations from Jayber are constant. Military families rotate on 2 to 3 year cycles, and the steady stream of incoming personnel typically absorbs vacancies created by departing tenants. Pricing units near the current BAH rate ensures quick absorption. Fairbanks, home to Fort Wainwright and Eielson AFB, has a military-heavy market. Military lease breaks are routine. Fairbanks' extreme climate, the coldest major city in the United States, creates unique dynamics. Winter lease breaks are harder to fill because fewer people relocate to Fairbanks during the coldest months. Summer lease breaks, when military rotation season peaks and the weather allows moving, fill more quickly. Juneau, the state capital, has one of the tightest markets in Alaska. The city is accessible only by air or water, which severely limits development and housing supply. Re-rental in Juneau is typically quick given the persistent supply shortage. But the geographic isolation means landlords have limited advertising channels. Local listings and word of mouth are primary tools. Kodiak has a Coast Guard-influenced market. Military lease breaks from the Coast Guard base are regular. Sitka, Ketchikan, and other Southeast Alaska communities have small markets with limited demand. Remote Alaska, interior, western, and North Slope communities has extremely limited rental markets. Re-rental in these communities can take a very long time, and pursuing breaking lease damages against a tenant who relocated to the lower 48 may be impractical. One best practice for Alaska landlords include a clear early termination clause in your lease that accounts for Alaska's unique dynamics. In Anchorage and Fairbanks, where the military population drives regular turnover, a fee of 1 to 2 months' rent with 60 days' notice is typical. In Juneau, where supply is extremely limited and re-rental is quick, a lower fee may be more appropriate. Calibrate the fee to your realistic expected vacancy in your specific market. Another best practice, for landlords serving the military market, have an absolutely streamlined SCRA process. Military families are your primary tenant base in many Alaska communities. Treating SCRA terminations as routine rather than adversarial maintains your reputation and your occupancy. Process SCRA terminations quickly, return deposits within the statutory timeframe, and document everything. A third best practice: take heating failures and winter habitability issues extremely seriously. In Alaska's climate, a heating failure is not a maintenance inconvenience. It's a life-threatening emergency. Have backup heating plans, maintain emergency repair contacts, and respond to heating emergencies within hours, not days. A tenant who terminates because of a heating failure during an Alaska winter has one of the strongest constructive eviction claims imaginable. Alaska limits the security deposit to 2 months' rent. The deposit must be returned within 14 days if there are no deductions, or within 30 days if the landlord needs to assess damages. If the landlord fails to return the deposit within the required period, the landlord may be liable for up to twice the amount wrongfully withheld plus attorney's fees. These rules apply to broken leases and normal move-outs alike. For the complete guide to Alaska breaking lease laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our Breaking Lease Law series.